Hello, welcome back. Welcome back. We are going to join the hearing when it resumes based on social media poll. Approximately 80% of you. Let me just check and make sure we're at the 80% mark. And it tells me 82%. So if you have questions, if you're watching this on Twitter and you have a question, I would engage with the Twitter or the X post. It's a live post, obviously. If you're watching on Facebook or YouTube, please share if you can. Take the opportunity to subscribe to the channel if you're not a subscriber. It is free. If you are watching, whether it be via X, formerly known as Twitter, Facebook, obviously YouTube, I would really appreciate it if you took the time to go over to the YouTube channel and hit a thumbs up. It just helps with regard to engagement. I'm going to check in here on the court and see if the judge is back out. Not as of yet. But I really think after speaking with a few different attorneys that they are sharing not only the complexity and the depth and the length of the litigation that has led to the settlement, but there is potential cause with regard to future athletes, the restrictions on the roster spots, the elimination of roster spots, a lot of potential landmines. And I think this really is something that will really cause a significant amount of initial turmoil with regard to May and June of this year for all sports, not just baseball, but particularly baseball. Want to reemphasize, had a lot of messages come in asking me about why I'm so adamant about this professional division. Well, the old adage, follow the money. And the money is in the big boy world. As one, you look at March Madness that, this evening, you're going to watch Houston and Florida. It's big money. And March Madness is an NCAA entity or owned event, unlike the bowl games, which are more conference driven. June, the regional, super regional, and ultimately the College World Series. NCAA runs, manages, and owns that event from a monetary, from an income generation perspective. So if we just take a look at where the money is being generated, who's generating the most money, some people don't like to share well with others. And so therefore, I really believe you're going to see Division I college athletics become the D League, minor leagues, however we want to title it, for professional athletics, hockey, lacrosse, everything like that. So that's what's on deck. But let's go to live coverage. If you're liking this, can you engage, whether it's with X, Facebook, or YouTube? Please, if you can, just engage. That would be great. And let us go to live coverage.
You help keep lunch break going, and most people here, so that's more than you can say for a lot of legal counsels talking on a YouTube show. So I appreciate the great answers there. Let everybody know again about you in case they're just joining, and what you do, or where they can find.
Want to let everybody know that while we're waiting for the judge to come out, I think it's important to understand, while this may be boring for the vast majority of people, this does impact whether you are the parent of a current college student athlete, a prospective future college student athlete. What may be mundane and boring with regard to legalese and listening to people talk, if you pay attention, you hear we're talking Title IX, the implications not only with regard to the settlement, but moving forward with regard to Title IX. We're also talking about the elimination or potential elimination of roster spots throughout all of athletics, not just football or Power Four. Again, this settlement pertains to NCAA Division I. And, their biggest concern is the chaos that could ensue within the portal. You're already seeing it with basketball. You've seen it with football, likely to, move forward with softball and baseball and other sports. But you're seeing a lot of colleges and universities are trying to get their current athletes to sign their name, image, and likeness agreements for next year today or this week before the actual finalization happens. We don't know. We can assume that things going forward are going to be skewed or leaning towards student athletes as opposed to the colleges and universities. We've heard dribs and drabs with regard to antitrust. We've heard from the HBCU college athletes. We've heard from the female athletes, Paul Skeen's fiance, girlfriend, LSU gymnast. She spoke. We've heard from female lacrosse, swimmers, sports that are referred to by athletic departments as Olympic sports or non-revenue generating sports. Another dynamic of all of this, as the judges will soon be sitting down, that people have to keep in mind, and the other reason why I think we're going to see a professional division and a lot of realignment, is there's no way that college athletics, whether we're talking mid-majors, can afford 3 to 5 flights. Take a school coming from the East Coast to go to the Midwest, or the East Coast to the West Coast. Those things add up. They're 25 to 50,000 between flights and hotels. And you start talking about non-revenue generating sports. It's one thing to do that for your football team that is playing every Saturday for 11 or 13 weeks. It's a whole nother to play for your basketball that's playing 40 games, and baseball playing 56 games, softball, crew, tennis, golf. So somewhere there's going to have to be obviously a realignment based on geographics, I would imagine, things that make sense from being a fiscally responsible and having budgetary concerns. Obviously, that's going to have to be weighted into. And again, I gear everything towards 2027. We're almost at the midway point of 2025. Television contracts for football and basketball with the big boy P4 conferences, expire in 2026. So obviously moving forward, we are going to see A, changes to the television contracts, B, the revenue distribution. But I think we're going to see future litigation, coming from a variety of different angles, which is what they're trying to kind of discuss here this week, based on whether the judge agrees with the settlement, adds any sort of stipulations. I don't think it's going to be a matter of law or precedent being set. I think they just agreed to settle this particular suit. And for those of you that aren't familiar, and I know I'm being repetitive, but this suit was initiated or began or is founded with Ed O'Bannon, former basketball player at UCLA, who took the NCAA to court based on the video game by EA Sports, and thought that he was an athlete that was being portrayed on that particular game, and thought that he had his name, image, and likeness from a monetary perspective. So that's what this is all kind of stemming from. And over the years, the money's being generated through television and obviously social media and so forth. And athletes stood up and really wanted to be rewarded and compensated as much as, if not more than, the colleges and universities. Currently, the settlement goes back 10 years retroactive to 2016, approximately 10 years. I really have to think that this is going to go back to 2009 when it's all said and done. If the case was started, you know, in 2009, then the athletes from that particular time period are going to have some sort of due process, I would imagine. Let me know if you like this type of content, if you can kind of engage, whether it's with the X, send me a comment where you're watching from. If you're watching on YouTube or you're watching on Facebook, you know, go ahead and send me a comment here. Let me know that you like this type of content or you're liking this type of content. I've heard from several of you via text message and direct message, and I appreciate your comments. It does help me with regard to growing the channel and the platforms if you can engage with the YouTube channel. Just switch over to X, over to YouTube. Say hello, engage, subscribe, obviously, and also hit the thumbs up button there. Thank you, Tara. Hit that thumbs up button there, Tara, and I appreciate you, and Monique, and all of those others that are watching. So we are about to get started here. When the judge comes back, I think she is going to allow a few other NCAA attorneys to speak. And I think this is going to get to the heart of today's hearing, which is I don't think we'll receive an opinion today by the judge. I think that will be at some point later this week. I think it's in the best interest of all parties, both parties here, to at least agree to move forward. And then the high school athletes that are affected, as well as those athletes, I think they're going to come back and, you know, file an injunction of some kind. That would be my opinion. I'm obviously not an attorney, nor do I play one on television. But I think that they have to make the high school athletes that have agreed and signed letters of intent, which were agreed upon previous to this settlement, you know, they have to at least be given the opportunity. And I don't think coaches really want to jettison, cut, you know, sever ties, however we want to quantify it, classify it, with those athletes in the fall. I think everybody wants to come to a number that they can move forward with, starting August 1st, September 1st, first day of classes, what have you, and then that's your roster for the year. I do think you're going to see some chaos in May and June. So we're going to discuss that a little bit more in detail tomorrow night. May or may not have a college coach join me tomorrow evening to kind of give their thoughts and opinions. I think it's important to note, as I'm getting text messages while I speak, it's important to note that college coaches are only giving their opinions. They certainly are not speaking for their institutions. They're simply taking what they are getting for information, and then obviously, you know, we'll begin to make the necessary changes that their athletic department, athletic director, presidents of the universities determine how they would like to move forward. So again, I encourage you, as the judge is coming back here, she will sit down. They will begin to hear from the attorneys, believe from the NCAA, as well as the academic institutions that are participating here in Oakland, California. You know, I'm in the East Coast, on the East Coast, and so we're 3 hours behind. A little bit different, but I thought based on my poll and based on people I've spoken with, that I would go ahead and put this out there in the world of X / formerly known as Twitter, YouTube, and obviously Facebook. So I hope you're enjoying this type of content, and let me know your thoughts, you know, during, after. If you have any questions that I can get answers to for tomorrow evening's live discussion Q&A. You know, a lot of the social media platforms do not react positively with regard to engagement when it's long, it's live, and I get that. We don't have long attention spans, but I thought that this is something that parents, whether they're watching live or find their way to over the next few days or weeks, will find interesting to give them access to the actual hearing. So it's not my opinion or somebody else's opinion. You can actually hear, you know, the questions that are being asked by attorneys, by student athletes, by members of colleges and universities that are about to step up here. This is a whole different world, and I really think the business of athletics, which started, you know, obviously decades ago with regard to college and professional athletics, and then we got into youth, the business of youth athletics, which is now evolved and is at the pinnacle with regard to the business of college athletics, which takes on a whole different meaning. You know, I know athletes that are signing name, image, and likeness agreements for lots of money. And, you know, there's a lot of people, I won't say taking advantage, but because you as parents or you as student athletes don't have access to information like this, sometimes parents are made to feel nervous and unsettled, and therefore they make decisions that might not be in their best interest. But here we go. The judge is back.
Who do we have left who's still? Well, I want to hear from class counsel and defendant's counsel, and which of the objector attorneys are still here who still have something to say. Pardon? Oh, they're on Zoom.
Yeah.
Oh, right. We're not finished with the original speakers. So it's what, Mr. Ellis?
Yes.
Oh, okay. Oh, they're all on Zoom?
Yes.
Oh, sorry. Sorry, we had trouble with our Zoom, so I forgot about it. Okay, so we're hearing from Mr. Ellis.
May I proceed, Your Honor?
Yes, please.
Good afternoon, Your Honor. My name is Andrew Ellis, and I represent objector Alex Vogelsong. In Ann Kim and Ortiz, the Supreme Court warned of the danger when gigantic attorney's fees hinge on a global settlement of all claims.
Okay, I'm not as interested in that issue as I am in the due process issue in terms of certifying a class of future people and potentially releasing claims that haven't come about yet. There's some of the issues are the same, but I'd rather hear about the other one, if you don't mind.
Absolutely, Your Honor. So let me go to the injunctive relief portion, because I know you're interested in that. Although I think some of the conflict analysis,
Okay.
some of the conflict analysis is going to be the same. So on the injunctive relief, the settlement gives the NCAA a decade of antitrust immunity, blocking even future athletes still in elementary school from bringing claims into the 2030s. As Your Honor is aware, it also sets a salary cap without the involvement by a players union, takes away roster spots and scholarships from a substantial number of athletes, and imposes some onerous restrictions allowing the NCAA to police NIL payments. Now, if a deal is going to sign away the rights of athletes for the next 10 years, that deal should have been handled by separate counsel and not the same lawyers focused on securing a $2.8 billion damages award.
That's not what I'm worried about. I'm worried about the due process issues. Can you have a class of future people who aren't known yet? Can they be understood to release claims for things that haven't happened yet? Due process issues, that sort of thing. I know the facts about the alleged conflict of the attorneys, but I'm more interested in the problem of future class members and future claims. They can't get notice. They can't object before it's approved. What about that?
Your Honor, I think the
Thought it was
answer
something
is,
you- I thought that was something your brief addressed. You weren't here at the last hearing. Your partner, whose name I can't pronounce, was here. You're in Mr. Brosthus's firm?
that's right, Your Honor, Mr.
Yeah.
Groshhaus's firm.
Okay.
Your Honor,
And your papers, I thought, raised that issue, and that's an issue I'd like to talk about.
absolutely, Your Honor.
But I don't want to put you on the spot if it's not something you're prepared to talk about.
It is something we're prepared to talk about, Your Honor. The answer is yes, future claimants can release their claims, but what the through line of AmChem
Can release their claims?
pardon, Your Honor?
Can, did you say?
Yes, they can. But
Okay,
the through line of AmChem, Ortiz, and all the way to Payment Card is that they can only do so if they have separate counsel advocating just their interest. So from
these are people that we don't, these are our iconic 10-year-olds on the asphalt. Are they literally going and talking to lawyers, or are the lawyers just sort of volunteering and saying, when you grow up, I'll be representing you, Sonny? Or
well, Your Honor, you're right that at this point, there is no traditional attorney-client relationship. But what AmChem and especially Ortiz said is you've got these class of folks that may not have claims yet. So in Ortiz, it was people that have not yet come forward with asbestos injuries. But what the court said there is that it's obvious that after AmChem, a class divided between holders of present and future claims requires division into homogeneous subclasses with separate representation. So yes, we don't know who these claimants are yet, but we need separate counsel that's only devoted to their interests.
okay, well, we didn't have it. So is that the death knell, or is there something that you can propose?
So what the remedy has been in a
You say they can pursue a claim. I'm surprised to hear you say that. How do they do that if they're 10 years old?
well, Your Honor, they could not pursue a claim yet, but I think this is, can they be bound to injunctive relief into the future? And what a line of
They
case,
can without notice or opportunity to object?
that's right, Your Honor.
They
So
have
it's,
separate counsel, but they don't meet them because they're 10 years old? I mean, I'm just not sure how this would work.
that's right, Your Honor. So that's what the court said in Ortiz. So if you've got a division between holders of present and future claims, so some of these folks have future claims, the 10-year-old on the asphalt, the way to remedy it is through separate counsel that's solely devoted to their interests.
And that's the only way.
That's the only way I've seen in all the cases. Now,
In a case, anything else,
anything else?
other than solving the requiring that the problem be solved by having separate counsel. That's the only way to make it work. And there's no other case that has any other way of doing it, and you can't think of any other way?
Not that I've seen, Your Honor. Plaintiff's
Okay.
counsel
Did you have
points
other things you wanted to talk about then?
Yes, Your Honor. So first on the partial scholarship claims, these are claims that were never litigated, never valued by plaintiffs, and only tacked onto the complaint after the preliminary approval hearing. Then these claims were released for zero consideration. Federal courts in the Ninth Circuit, and we
I
cite,
don't think that's right. They weren't added after the hearing. They were there at the hearing.
in the third amended complaint, which was amended after the preliminary approval hearing, is when you first have some of these partial scholarship.
That's when I allowed it to be filed, but they tried to file it long before that. But anyway, go ahead.
In any event, these weren't litigated. They weren't part of the class certification briefing, and there was no discovery taken on these cases. And they were released for zero consideration. So in our view, similar to in Gonzalez, this is unacceptable, and at the very least suggests that separate counsel should have been appointed. I know plaintiff's counsel has made the point that these partial scholarship claims have no value. And that is despite the fact there was no discovery taken. As the court said in Gonzalez, if plaintiffs believe that such claims so lacked merit and worth, plaintiff could not possibly represent the best interest of any class members who have those claims. Now,
And claims actually weren't worth very much.
well, you're saying in this case, Your Honor?
Well, you were saying it's if counsel thinks a claim is not worth anything, then they're not adequate counsel. And I'm saying if they think it's not worth anything because it isn't, then they're not inadequate.
Well, Your Honor, a few responses there. First, they made that determination with no valuation. And in Gonzalez and Guthrie,
I don't know. We'll find out, I guess. But I mean, these people have been suing the NCAA for 10 years and are extremely familiar with it. So maybe they didn't know anything about it or care anything about it. I'll ask them shortly. But go on.
well, Your Honor, I think that's part of the issue is they rely on some of their experience from a case such as the walk-on football case, which was filed in 2004. And they rely on multiple cases that are all pre-Alston. Both the facts and the law have changed in the intervening years. On the law, cases such as Alston and O'Bannon have now recognized that not all of the NCAA's restraints can be justified. In two cases that Your Honor has presided over, there are now certifiable classes of athletes. And third, the NCAA.
Certifiable classes, what?
I apologize. They have pointed out that they think there's no way to certify these classes. My point is that might be based on a case from 2004, but one thing that has changed since 2004 is there are now classes of athletes that have been certified, as you are very well aware. And the third thing that I would point out that has changed with respect to the law that makes these claims more valuable now is that the NCAA no longer contests that there are relevant markets for Division I sports. And that is something that hindered the Agnew case that plaintiff's counsel cited in their papers. If I could move on, Your Honor, to some of the NIL claims. We think another large conflict is that the settlement pits claimants with NIL claims against those without NIL claims. Just to be clear, the vast majority of damages class members receive 0 NIL dollars, and those without NIL claims only receive pay-for-play damages. Plaintiff's counsel has estimated that there are 380,000 additional sports class members that will receive, on average, $50 in pay-for-play damages, or $5 a year for 10 years before attorney's fees and taxes. It gets even worse for athletes whose careers ended by 2019. For athletes in sports other than football and basketball whose careers ended by 2019, they are part of the damages class in the settlement and have released their claims or will release their claims, but they receive $0 under the settlement. So just to be clear, for those class members that played in sports other than football and basketball, whose careers ended by 2019, they get 0 broadcast NIL, 0 video game NIL, 0 lost opportunities NIL, and they also get 0 pay-for-play damages. So they get nothing despite the fact that they are releasing all their claims. And that's potentially tens of thousands or hundreds of thousands of class members, since the damages class starts in June of 2016. So in contrast to the treatment of claimants with no NIL claims, the average football and basketball player receives over $100,000 in just NIL payments. And there are some NIL class members who will receive over $1 million. The vast disparity in the NIL and non-NIL payments, which I mentioned, mostly get either $5 or nothing, presents the same concern expressed by
the source of the money is endorsements and social media and all these things. And in order to get that money, they have to show that they did that. And people who didn't do it, it's too bad for them, but they just weren't damaged by that. Isn't the reason they didn't get the money. Maybe they didn't get enough touchdowns or I don't know what, but it's, if you, I mean, the method used to calculate lost NIL opportunities seemed reasonable. And if it is, then, and you can't show that you would have had some, then it's, like I say, it's unfortunate, but I don't see it, I don't see where it's a violation.
Your
And
Honor,
there was some answer in the most recent filing, I think, from the plaintiffs about money that the non-NIL people got. Maybe it was pay for play. I don't know.
so Your Honor,
Hear about it later.
we're not necessarily quibbling with the way that the NIL payments were calculated, or even the lost opportunities NIL. What I am pointing out here, or trying to point out, is that there is a big conflict between those claimants with NIL claims and those without NIL claims. And the settlement majorly advantages those with NIL claims over those who do not have NIL claims. And
It was, they respond by saying it's covered by the additional compensation fund. That's the pay for play fund, right?
that's right, Your Honor. So
Why do these people not get anything from the pay for play fund? Oh, because it's expired, the statute of limitations is expired?
so the pay for play fund starts in 2019. So there's
So the reason they don't get any money out of that is because the statute has run on them. Right?
So they don't get any money out of that because the statute of limitations might have run, yes. But then they're also not getting anything out of NIL, but they're still releasing their claims. So our point is some of these class members would have NIL claims if they,
But
but they were releasing them under the settlement for no money. So they're getting absolutely nothing out of the settlement.
if they had nil claims, they would get damages for them. I can only assume if their formula didn't work out for them, if they couldn't show their lost nil opportunities and so on, that it's because they weren't there. And as I say, well, never mind, we're going around in circles. Is there anything else you wanted to cover?
Well, just on that point, Your Honor, I would just point out that under their calculation, if you completed your athletic career before 2021, you got zero lost opportunities NIL. So there's these claimants that by definition, the way they calculated it, were not eligible. So they maybe would have made some lost opportunities NIL that maybe played from 2016 to 19, but they didn't get any based on the way that plaintiffs and defendants have structured the settlement.
Because the statute of limitations had run again? Or some other reason?
No, Your Honor. So
Why didn't they get any money?
So the way that
Nobody's getting any money unless the settlement goes through, but why are they not in a line for some money?
So the way that they've structured lost opportunities NIL is that you have to show that you would have made money from endorsement deals after 2021. So anyone that played completely.
Well, that's because before 2021, they weren't supposed to have endorsement deals.
That's right.
2021 is when they started being allowed to have them. So,
But so what I'm saying, Your Honor, is that you've got these potentially hundreds of thousands of class members who are releasing all their claims under the
there's
settlement.
390,000 altogether, including everybody, but sorry, go ahead.
Well, Your Honor, I think that doesn't count the hundreds of thousands that are getting $0 under the settlement, but from 2016 to 19.
Okay.
Okay. And Your Honor, if I could just make one other quick point. I know plaintiffs and defense counsel have said that settlements are creatures of compromise, but the settlements, the key question, I think, is who gets to negotiate that compromise. And we submit that all class members should be able to participate in the negotiations through counsel owing allegiance only to that group. The Ninth Circuit recognized 3 different structural conflicts in Volkswagen. And we believe that all of in Volkswagen, that's
Volkswagen. Oh,
right. They identified them where there's 2 subgroups that may have differing interests in the allocation of settlement funds. class members with higher value claims that have interest protecting those claims from class members with weaker ones, and class members with lesser injuries who may settle with more valuable injuries more cheaply. And then also where the agreement is so unfair to certain subsets. We believe that all of those apply here. You've got class members with NIL and non-NIL claims that had different interests in the allocation of funds. And most 380,000 of the non-NIL claimants are only getting $5 a year. You've got certain claims with higher value that were lumped together with weaker ones. We point out in our briefs that the post-2019 claims were of higher value than the pre-2019 claims. This is very similar to what happened in Ortiz, where pre-1959 claims were lumped together with post-1959 claims. Third, we think that, as I mentioned, releasing partial scholarship claims when there are good reasons to think that the law and the facts have changed, that these do have value for $0. And then also releasing class members' claims from 2016 to 19 for $0 and most only getting $5 a year is unfair. So for all those reasons, we think the settlement agreement as written is unfair, inequitable to certain class members, and there are at least 3 conflicts that prevent it from being approved here.
Okay, Mr. McGlamry? You're on Zoom as well?
Yes, Your Honor.
The microphone
Bill.
has a red line through it. Can I be heard?
Yes.
Okay. I'm sorry, Mr. McGlamry?
Thank you, Your Honor. Mike McGlamry on behalf of Objector Castellanos, and you'll be happy to know that I expected to have 5 minutes, so three capitalized words, college football playoff, appeared as a distinct releasee in the settlement agreement, separate from and not as an affiliate of any defendant. These words, 3 words, do not constitute a legal entity or other legal person. These 3 words are not defined anywhere in the settlement agreement, although lawyers, but not class members, know that capitalizing words in a contract denotes a defined term. These 3 words do not appear again anywhere else in the settlement agreement.
I'm sorry, words again?
Excuse me?
What are the words again?
College football playoff.
Oh, that. Oh.
Okay.
Yeah, somewhere somebody gave a list of about 5 different organizations that had that name. So it would seem like we could just put all 5 of them in there. And then the remaining question is whether they should be released or shouldn't be released, or they should pay money or shouldn't pay money. And that's.
And that's where I'm going, John. That's where I'm going. Thank you. And they don't appear in the motions for preliminary approval or any notice. And the abbreviation CFP is not mentioned anywhere in the motions or any documents. And as you know, Your Honor, due process requires class notice that provides class members sufficient information to allow for educated and informed decisions. And
Well,
no
are
one
they
can
not
make-
just the same as you know how these releases are. They always say we release the affiliates and the agents and the blah blahs and the ECX and every, 6 different ways of putting in the thesaurus who you could be releasing. So here, instead of leaving it at that, they mention one entity. I don't see a big problem with that as long as we know what the entity is, and as long as we are satisfied that that entity isn't like somehow hiding the money or the money's being filtered to them. I don't know if you have any evidence like that.
Well, Your Honor, as I get there,
Why do you think they should?
At some level, I think you're right, and I agree with you, but we don't know that. And of course, that's what we're trying to get to, because obviously class members were entitled to make an informed decision. And you can't make an informed decision about an unknown, undefined, non-party, non-entity that we believe is not contributing to the settlement. And again, in the releasees, it's not saying the defendants and any affiliates, it's saying college football playoff and any affiliates. So again, we're talking about who we're talking about.
Okay, so
And-
what do you think they might have done that they shouldn't be released for? I mean, what?
We don't know. And what we're trying to get to is, in my experience with something like this, when it's something this complex, the defendants draft the settlement agreement. And the plaintiffs, I don't believe, would author the releasees because typically they settle with the defendants, right? And here I would think that if whoever college football playoff is supposed to be in terms of entities, if you wanted to give them a release, particularly with the sophistication of the defense lawyers and plaintiffs lawyers here, those would all be named because, you know, you would want to make sure those names were all in a document. And of course, they're not there. And so
Well, I haven't to ask this, but did you do any discovery to see who they were? I mean, do we have any evidence or any suspicion or any reason to think something is going on here?
Well, Your Honor, I've only been brought in recently, and we filed 2 briefs. We filed our objection, we filed a brief, and the plaintiffs have not said. We've asked twice. The defendants have basically ignored this and obviously tried to put the burden on the plaintiffs to respond. And so no, we don't know who they are. And we've done a Google search, and you mentioned, Your Honor, earlier, these entities, CFP Administrators LLC and CFP Events Inc.
Somebody submitted that. Somebody disclosed those names because.
And we did.
I didn't Google them. I read them in somebody's brief. I don't know which brief it
And it
was.
was our brief.
Anyway, let's go on.
It was our brief, Your Honor.
Too much time on this issue. I'll ask them when they come back who these people are and where they get their money and whether they're getting any.
Right. Well, and of course,
other subjects you wanted to talk about?
no, Your Honor, we wanted to talk about that because what the plaintiffs ultimately came back with, they said, well, we're not going to tell you who they are or whether, you know, what's going on. What they said was, let's wait and find out in future litigation. And what they said was, if a question arises in a future lawsuit about whether a particular entity is encompassed by the release, it can be resolved at that time. And you know, of course, from our perspective, you know, a release is intended to avoid that, right? And you know, it should have been, in our opinion, in the settlement agreement and the notice, and they should have responded in the briefs to tell you and the class members. Instead, essentially, we believe they hoped nobody would catch them, and then they wouldn't tell the court. And you know, what I sort of feel like, and I know this is, you know, making light of it, it's almost like Herbert Newberg rolling over in his grave to think that you're going to put something in a settlement agreement and not tell people what you're talking about. And essentially, we think that's
that joke or too young for it.
Excuse me?
Am I too old for that joke or too young for it?
Well, probably too young for it. I'll go with that one, Your Honor. It comes back to where Mr. Claro started, which was his binary question of whether or not, this settlement ought to just go through because it's, there's a settlement and we ought not look at the individual objections and what the answer to that question would be. And in our perspective here, we have a due process argument, and if it's up or down, it ought to be rejected. But Your Honor said earlier on, and I think you're right, we ought to look at this question, and we would ask the court to get the parties put on the record who they contemplated, who this was supposed to be, what entities, who should be in a release. Did they?
Okay, I'll ask them.
Settlement and half.
I'll be here. They'll be back. I'll ask them. Was there anything else?
No, Your Honor.
Okay, thank you.
Thank you.
And then the next thing I have listed is Buckhalter, but that's a firm, not a person. Is there someone named Mr. DePepe here who's maybe
Yes,
from?
Your Honor. Yes, Your Honor.
Room as well?
Yes.
Oh,
Douglas DePep, Your Honor, from Buckhalter, representing objectors Berg and Likens, as well as several anonymous Division I athletes.
I see. Okay.
Thank you, Your Honor. A lot of ground has been covered. Being, I think, the last speaker of the day, I hope not to rehash.
Last, I think.
I'm sorry?
Wait, never mind. Sorry.
Hope not to rehash anything. We're focused on roster limits as well as interclass conflicts and the interplay between them. I think it would be useful for the argument that I'm making to just quickly give a snapshot of a chronology of this very lengthy case, principally the court certification of the injunctive relief class, September of 2023. Of course, the injunctive relief class is, I'm sorry, the settlement terms for the roster limits is in the injunctive relief class. After the certification of the class, the parties negotiated, and the NCAA announced in the summer of 2024 the terms, including a mention of roster limits. So therefore, then notice, of course, occurred once the preliminary approval occurred in October, and the notification process started. So I share that with the court because at the time of the injunctive relief settlement, all of the objections that have come about and the controversy was not before the court. Now the court is aware. Now,
About the roster limits? Or what controversy was not before the court?
the number of objections about the unfairness of the roster limits.
Oh,
And as the student athletes eloquently explained, it's not just the fact that they may be losing a roster spot. And as the court mentioned at the outset, sometimes bad things happen in life. They're unfortunate. However, we don't see it that way. We're articulating, and we compared what's fair, which is, you know, a bit of a flexible term, even though there are court decisions on what's fair, reasonable, and adequate. We compared that to unfair, deceptive acts and practices law in the different states, because if something offends, known as UDAP, if something offends UDAP, then it can't be fair. And what we've pointed out in our brief is the manner in which this rule change, the roster limits rule change, has been brought about. So if you look at the period this summer when after or during the time frame that the NCAA announced the plan or the expected settlement and filed the parties filed the motion regarding the settlement terms and the settlement agreement. During that time frame this past summer, Your Honor, athletes were being recruited, were being offered scholarships, and were making a life decision to enroll at a university with the expectation that that's where their future would lie. And we can do two things at once. We're not against this change in the college sport landscape and the opportunity for athletes to make NIL money and revenue sharing. That's all great. But Your Honor, we can do two things at once. We can have a landmark outcome here to benefit athletes, and we can also, the NCAA can also implement a rule change that's fair and equitable, and that protects the student athletes that they purport to promote. So the manner that this rule change came about is now caused coaches, because it went into effect, it goes into effect next year. However,
settlement is approved.
if it's approved, right? But programs, Division I programs have to plan for next year, and they're cutting athletes or giving them notice that they will be cut next year now. So these athletes that anticipated being in college with as a student athlete with that expectation, they were given no notice of this change when they made that decision. And moreover, what's happening now, as Mr. Student Athlete Flynn mentioned, is that there's a lot of arbitrary and unfair cuts that are happening that none of these athletes anticipated. In fact, in some cases, they are being told that they will lose their scholarship, that they're not guaranteed.
Oh,
Understand that
if
that's
the settlement goes through. If the settlement goes through, yes, they might. But if the settlement goes through, they won't, is what I'm told.
correct. That's what the settlement, if it's approved, protects them. However, programs are dishonestly not informing athletes of that protection. And athletes are,
But that's not.
well,
Somebody
we submit, Your Honor, that the process that's been set in, that the NCAA and the college sport, Division I college sport, has interpreted this because of lack of guidance from the class counsel and defendants, has set in motion a practice that is patently unfair. And I'll give you an example. One,
isn't part of this lawsuit. It's not an antitrust violation. It may be bad. It's unfortunate. I'm sorry that's happening, but I don't see how it's relevant to this case.
The antitrust law is tied to the history, and then we put this in our brief, of UDAP statutes. That's what the beneficiary of
I'm out here, but what's a UDAP statute?
Unfair and deceptive acts and practices law in the states.
Oh, okay.
The Clayton Act was passed the same year as the FTC Act, and they go hand in hand. And so if the beneficiary of a free enterprise and competition in the market, Your Honor, the beneficiary of that in many cases are also consumers. And the consumers, the athletes here, are being harmed by the process set in motion. I said a minute ago that we can do two things at once. There needs to be a transition period for the roster limits. You know, that you had mentioned, how could this be implemented? I think Counsel Rutherford mentioned grandfathering them. There's a fair process to protect these athletes that we believe is necessary. It's not just a so as it exists right now, this is a fair, reasonable, adequate settlement determination because of the unfairness to these athletes that are being cut without adequate notice. We believe it's not fair and it should be rejected.
Okay, thank you. So I believe that's it for speakers. And what I'd like to do now is go back to some of the things that we didn't really have time to cover. I'd also need to have a break after 90 minutes. And of course, we started late. So will someone tell me when it's, Renee, will you tell me when you're ready for a break? And I know we've got what, class counsel at this table and defendants counsel at this table.
That's right.
Who I can't really see because this is not my courtroom and I would have it set up differently. I'm sorry, it's sort of awkward, but if I scooch forward, I guess I can see you. I suppose there's still people on Zoom who are just on the webinar, but not promoted to speaker, right, Tracy?
That's correct.
And there may be some objector attorneys still in the courtroom. I'm not going to ask every question. I'm going to ask the questions of who I think might have an answer of either plaintiffs or defendants. There may be some instances in which an objector might have an answer that the plaintiffs or the defendants wouldn't have, but I don't know which ones are still here, which ones would have what answer. I do have a list of what each one talked about, but I don't know who's still here. Maybe I could get any objector who feels that they're going to want to talk some more. I guess that's the wrong question to ask a room full of attorneys, huh? But if I could have any objector who's already spoken, but feels they may have something to add on some of the topics that I hit upon at the very beginning. If you could come up to Tracy and give her either your card or your piece of paper with your name on it or something like that. And feel free not to. I can't call on everybody for everything, but okay. So the first thing I want to bring up is probably goes without saying, and it's out of order, but I just want to make sure I say it, which is somebody mentioned earlier that there were no objections to the Hubbard settlement.
No, Your Honor, there I think were 4 or 5. They were only about the individual allocation mechanism, a complaint that someone thought they should get more, or that the mechanism didn't appropriately value their services, and we didn't think we addressed those in those briefs. So unless you have any questions about that, we think those are all the types of objections that would not be a basis for withholding approval.
Okay. Now that, I suppose we still need to be on Zoom, right? Because there's people watching on Zoom. Is there a camera on you
Oh, I'm
all?
sorry, should I come up here?
Well, I don't,
There's cameras.
I hate to, the cameras are up here at
Yes,
the,
there's cameras for each. podium.
but not at the council table.
No.
So we should come up to speak then.
I guess you're gonna have to.
It's your honor, so I'll repeat that again.
No, it's,
I'm sorry.
I'm sure they heard you. and They
Okay.
can get along without seeing you for a few minutes.
Okay.
Oh, is this it? Oh, great, okay. So what I wanted to say is that, okay, there's just a few Hubbard objections and they might easily be dealt with. And in addition to that, there aren't really many objections having to do with the damages in the House case. And I know I asked you this question last time, Mr. Killaroo, but I'll ask it again. Why don't we just settle the Hubbard claim and get that off our plates? Maybe settle the Alston damages claim and get that off our plates, and then concentrate on the issues where there are issues.
They're all tied together, Your Honor. The settlements
So
are
you
contingent
say-
on each other
That's because you want to do it that way.
because it's in the terms of the settlement agreement.
Oh, I know that. Oh, I know that. Oh, if I could do it without your agreement, I would. No, I know it's in the agreement. You'd have to agree to it.
We won't agree to that, Your Honor.
Well, how about giving it some thought? How about talking to your clients about it after today's hearing?
We can talk to them about it, Your Honor, but I think we've evaluated this one. You raised the same question of
I know.
preliminary approval.
I
Our
admitted
answer is
that.
the same.
I admitted that right from the beginning. Okay,
Your Honor, I just would say you can
I-
separately approve Hubbard, but under the agreement, no money would be paid. They have the right to withdraw if the other settlement is not approved, but they are two separate.
okay. Well, maybe I
Approval
should just
decisions.
approve it.
So you could just approve Hubbard
Okay,
but there will be no payments that we could disperse until the issues with House are resolved.
and no downside.
Right, there's no downside to just
Why don't I
approving
just
Hubbard,
approve
that's
it?
correct.
Your Honor, it's a condition of the settlement and of us putting money in the fund that all of the settlements be approved together.
Right, no, I'm aware of that. But I guess maybe it might make a statement. I don't know.
He is
I-
right, he doesn't have to pay
Yeah, I
anything
understand that
until
you
all
wouldn't
is
be
approved.
paying any money, but maybe it would. And what about the damages in-house?
So the only objections to the House damages, there have been a few people who have individually complained, I don't like my allocation, and we addressed those. There is this general objection, which you heard from the objectors saying that they think that the amount, the $600 million is not adequate, that there's been that's over 30% of the total actual damages. We went through all that. We don't think that's an issue. And then there was an additional comment made that claims that specific class members aren't getting paid for a variety of reasons. And Your Honor, again, these are either complaints about the allocation methodology or complaints about the statute of limitations or complaints that some people didn't have NIL damages and others did. And as we addressed all these in the brief, but we think when you look at the damages funds, that there's no question that they come within the range of reasonable approval. The NIL damages and the video game damages and the individual NIL damages are all above 60%, which is extraordinary in an antitrust case. And then every other complaint is about the allocation. And then, so we don't see any basis, for doing that. And the pay for play damages, the $600 million, are above 30%. And again, we don't think there's any basis for challenging that. But there have been some objections made that the amounts are inadequate or there should be more. And again, I don't think any of those actually are warranted in terms of looking at what's a fair, adequate, and reasonable settlement.
Okay, so let's assume I rule on all those. Is
Yes.
there any pro or con that you can see to simply signing something that says that this portion of the motion is granted?
So again, I think you could order this any way you want. Mr. Rakesh will say that, that they have no obligations until everything is done, which is correct. Your Honor, but you certainly could order and say, this part is fine, this part is fine, this part, and issue but I recognize he is correct that we have an integrated agreement where he has no obligations until everything is approved.
It goes
Yeah,
beyond that.
And again, it's not my courtroom, but there's a big opaque strip right in front of your face. If you could
I
possibly
move over here. How about that? Does that help?
That helps. Yes,
Okay.
thank you.
Your Honor, you know my position on Hubbard, but I
Yes.
just will say this makes even less sense respectfully. It's one settlement agreement. You literally have one settlement agreement that contains the damages and the injunctive relief. I don't think I've ever seen a judge say C's in, B's out, F's in. Like, that's not how settlement agreements work. So no, we wouldn't agree to approve some portions of the settlement agreement that are one piece and not the whole thing.
I guess I could write an order indicating what I would do if. Okay, so that's that. So what I'd like to talk about is this issue of certification of a class that includes future class members.
Your Honor, I'm
And-
prepared to address that when you're like.
And also certification of a class that addresses itself to future acts that haven't taken place yet and release somebody for acts that aren't thought to have happened yet but could happen. And I find it quite a difficult concept, and I find not many cases directly on point where such things have happened, even though you would assume that they would happen all the time. And so I don't really care who speaks first, but have I made myself clear about what the problem is?
Yes.
I don't care so much about should the same attorneys do damages and injunction. That isn't my problem. The problem is, can any attorneys do anything to people who aren't yet on the earth or in a situation? Now, there's the asbestos case where they have a difference between people who've already gotten sick and people who've been exposed but haven't gotten sick. There's this statin case, which is kind of an interesting case. I'd be interested in hearing what both of you have to say about that one. And then I'm interested in what possible fix could there be? Could we, well, maybe I'll just hear from you first and then I'll tell you.
Okay. So I think there are different pieces to this, right? One is process, which you might call the fix, like how could you organize it? And I want to address that. Second is, can you have a Beede II class that goes out with injunctive relief for a number of years, including affecting members who have not yet matriculated into the class, if you will. And three, how do the courts treat this? Are there precedents about that? And I could address each of those pieces, okay? First of all,
One other point on the representing future people, it's kind of it's this interest it's the adequacy of representation by the class rep, not by the lawyer, but by the class rep, because the class rep arguably or allegedly isn't sufficiently similar, hasn't suffered the same interest or injury. Query, how close does it have to be? When does it have to be? Does it have to be prior to approval? And well, just prior to approval, I guess you'd say.
okay, I'll address that too.
Okay.
Okay, so let me start first with the fact that have there been settlements like this? And the answer is yes, there have been many settlements like this. And I'll give you some examples, okay? Let's start with the White versus NFL settlement, because It's in sports. It created a system. It initially applied for 7 years, and it included not just people who were in the NFL in that time, but it expressly included in the class definition anyone who was going to seek employment in the future in the NFL during the next 7 years. That's
Okay, but was it a request for class certification under Rule 23 and an approval of a certified class that wasn't reversed?
it was a request for Rule 23 certification in a settlement that was challenged on appeal to the Eighth Circuit. The objections were overruled both at the district court level and then affirmed by the Eighth Circuit. There may have even been a cert petition that was denied. I just don't remember about that. And class members came in. These issues were all raised. And what the reason why this type of a class is permissible is because when you want the benefits of the settlement to go to the future class members as well. You spoke about the prodigy player in the 9th grade right now who might come up and be a swimmer or be a basketball player, a football player. You want that person when they come in to get the benefits of all these new scholarships. 24,000 new scholarships each year might be available. That's $1.2 billion in scholarships if you assume an average $50,000 price tag for those scholarships.
You want that benefit, but
Right.
can you also get the release?
Yes, so we'll come to that. But the first thing is the reason you have these settlements in many areas. So you have them in employment cases. You have them in Title IX cases.
Okay, well, I'm sorry, get back to White again.
Yeah, go back to what?
I've read, what are there, 8 different opinions?
There are many different
They
opinions.
say all
on
kinds
it.
of things, but what they seem to say is that it wasn't entirely clear that it was a simple, straightforward class certification. They're talking all about collective bargaining agreements and unions and.
So let me explain that, okay? At the time that the case was prosecuted in White, there was no union in existence under the labor laws. It had been decertified because the only way the athletes could pursue their antitrust claims under the law at that time was to not have a union in place. So the entire case was prosecuted. It was settled in a class action settlement with no union in existence at all. What's confusing is in the settlement terms, it said following approval. So not before approval, following approval by the court. A union might be formed if the players voted for it. They had to have a new election and vote for it within 30 days. And if a new union was not formed in 30 days, then the defendants had the option, but not the obligation, to say they didn't want to continue with the settlement and back out. And the reason for that was they wanted the protection of what's called the non-statutory labor exemption. And they wanted the option that if they didn't get a union in the future, that they may or may not have stayed with the settlement. But for your purposes, the settlement was done, and I was one of the co-lead class counsel negotiated it. We negotiated without any union in existence. There was no, I could go on oath, there was no union. It couldn't be because we wouldn't have been able to prosecute the antitrust claims. And the court had no problem in doing it that way. Similarly, in the Oscar Robertson case, which was a 10-year settlement agreement, Oscar Robertson versus NBA that we cited.
White, the one where the court said there really is no class settlement agreement here at all. One of the cases that you cite, the court enters that criticism and says this doesn't address this issue because there wasn't a class.
I don't know what your honor is referring to. I know it was certified
Okay.
as a Rule 23 settlement class,
Okay.
which was challenged on appeal by the Eighth Circuit. I'd have to go back and look and see what that comment was, but I know that's what Judge David Doty, who's still sitting on senior status in the District of Minnesota, he affirmed the class, and it was affirmed by the Eighth Circuit in terms of that. So that's an example. Robinson versus NBA is another example, was a 10-year settlement agreement that would apply to all the future athletes who were coming to the NBA, including those who were in high school at the time. Obviously, you have a 10-year period of time. You had a lot of people come up and grew into that. And those settlements all include releases that are part of what applies to the injunctive settlement as well. So they had releases into them that you come in. What we proposed here, though, is to give greater protection than actually were provided in those settlements. Because here what we propose is the following. And you're right, there has to be a process. We propose that each new athlete who comes in to Division I be informed with a notice. That notice, which we're going to give your honor to approve, would tell the athletes about the settlement, its rights, advise the athlete they should consult with either a parent or a guardian or an agent or a lawyer if they need help in their rights, and they could retain them individually. And if they want to object, they could file an objection. And we believe, Your Honor, both sides agree, there would be a procedure that you would put in your order, that we could put in the notice, that each year the court would receive all the objections and hold a hearing. If there are no objections, I guess you don't have to have a hearing, but if there were objections, you would have an annual hearing in which you would evaluate whether any new issues have been raised or concerns that would warrant any type of modification or change in the settlement. And I have to confess, I've never seen this procedure before. Both sides worked it out to provide greater protection here. In the other cases, this has been done without that. And Your Honor, the type of cases I'm thinking about, Your Honor, will be familiar with this. School desegregation cases all have multi-year injunctive settlements, whether it's going to be future redistricting or future, busing or other things that were done in all those settlements. Multiple generations go into in those settlements and have rights under them, and also release certain claims under them. And it's always been allowed under B3. All the employment settlements that have changes in hiring practices, hiring standards, future employees who go into those settlements, those injunctive settlements, didn't know they would go work for that employer. Right. I'm now working at Macy's, and now there's a settlement with Amazon. I didn't know at the time of notice of the injunctive settlement that I was going to go move to work for Amazon, but I am covered by that injunctive settlement, which may have changed the hiring practices and is there. So we believe there's no
And bound by a release.
and bound by
Away
and
some
each one.
ability.
Some may have releases, some may not. Now, importantly, you cannot release future damage claims. That's a big distinction, right? The only release here is with respect to challenging the terms of the injunction, right? That's what's being released here. You can't you can't go in and get an injunction against the injunction terms, if you will.
What can you do?
Because your right is to file an objection in the future. If you're already in the class now and you have notice, your right is to object now. If not, you're bound by it. In the future, you will have an annual objection right. And just like the court considering now, after all the objections, we agree the court can reconsider whether or not anything new has happened. Like the world, it seems like our world changes every day today, right? So maybe the world has changed in some radical way in which Your Honor will look at it and say, this was reasonable for the class 4 years ago, but maybe these objections now, it's not reasonable for the class, and you could revisit that, just like your court, you're retaining jurisdiction, anyone could always make a motion to modify a settlement or to terminate an injunctive settlement. Your Honor knows when you retain jurisdiction, those issues can be revisited down the road. You have to show changed circumstances and other things to do that. But the point here is we think this is totally consistent with due process, how this is done, how it's recognized in the cases in terms of these future issues. So we're very comfortable with this process. We agree with you. The details should be spelled out as to how these hearings would happen and, you know, and what was there. And we were going to do that in the notice. And you certainly could do that in your order to express when you retain jurisdiction, here's how these procedures will work. And here's what I will do in order to provide this. But it would make the opposite conclusion that you couldn't do this would mean you couldn't have any multi-year injunctive settlements involving future employment and conditions. And I think that would be, let me put it this way, I've never seen a decision the other way. I've never seen a decision saying, because this is a multi-year B2 injunction changing standards, that somehow this is a violation of due process and that you can't have it to bind those things. None of the objectors have cited that, and I'm not aware of any authority that has said that B2 cannot be applied in that thing. Because I think that's the very purpose of injunctive relief is going forward. Just like Your Honor, by the way, it's the same due process issue. When you entered your injunction in Alston that said they could have future cash awards up to $5,680, that's binding those high school students who come in to the NCAA who can now get that benefit, but they also can't get more than that. That resolved it in the future. So I believe injunctive relief can apply to people, you know, going forward for the class, even if you're not in the class at the moment the injunction is entered with respect to that.
What about I don't know if it's in Rule 23 or where it comes from, but the notion that not only do you get notice and opportunity to object as a potential class member in a B2 case, but those are supposed to happen prior to the approval of the settlement, not afterwards.
Right. So again, that's a dilemma in the sense that if you said that everyone has to do that, then you never can have a future injunction binding anyone who wasn't yet in the class. And I don't think that's the law. So the way we've dealt with that is make clear the court would have the authority to change the settlement, disprove it, you know, to take action if future objections raise concerns that would rise to that level. And we think that we were trying to head off this issues that how do you do this? And in terms of, you asked about class reps. So right now we have class reps who have standing, who are subject to the injunction. You're right, they won't be in future years, they'll graduate. We have said in the settlement, we're going to come forward and add class reps so that going forward, there is always a class rep, one or more, who is a current athlete, who therefore could be involved in supervising us as class counsel in those issues in terms of doing that. And we think, again, that's something that wasn't done in these other cases of injunctive relief, but we thought this was another good thing to do to give greater comfort that there would always be it. But in terms of what the law is at the time of the approval now, you know, of the certification, really the time of certification, you need to have at least one person who would have standing to bring the claim, and we have that. Right. And that,
but don't you also have to have notice and opportunity to object on the part of the class members who we can't give it to because we don't know who they are yet?
I believe because class is defined to include future members is permissible and is widely done in the courts, that there's no requirement that you can't certify a class that would include future members that enter into it. But I understand if you reach the decision that you only can have a class where people get notice now, then obviously you can't ever have a future class injunctive settlement that would bind anybody other than those who are there right now. I just don't
Yeah,
think
and
that's the law.
It doesn't seem, I mean, I take your point. It seems anomalous, but on the other hand, there aren't all those cases. There's maybe White. I'll have to go back and look at that again. The only one I could find was Staten. And that does not really analyze the whole situation
So,
too much.
The issue has not been discussed this way because it hasn't been challenged, right? But White covers it. The Robertson covers it. Alexander versus NFL covers this. Again, these are all multi-year. We cited these all in our brief. Alexander, Robinson, White. They all are multi-year sports class actions involving athletes setting up future systems. And it's correct, Your Honor, no one in Robinson or White said you can't have a class without giving future notice to these people. It just wasn't raised, but all these settlements have gone through, and all these other settlements involving future employment classes, involving prisoner cases. There are all these cases about injunctive relief on future prison conditions. These all cover people who not prisoners yet. You don't even know who's going to be in prison in the future. And again, I've never seen anyone, so I can't go either way. I've never seen a case say there's a problem in doing this because the members who will enter the class in the future aren't there yet. So how do we give them notice? I understand the question, Your Honor, but I think it is solved in our case in particular by giving this future notice and right to object.
Your Honor, could I make a brief point on that?
Please, go ahead.
Well, you can make a long point on all of it in a minute. But what if we didn't define the class to include future student athletes, but entered a multi-year injunction anyway? What about that?
So you could
Define the class to be current athletes but enter a 10-year injunction that says, here's what the rules are for the next 10 years.
So the
And
issue
the
issue there, the NCAA I'll let them talk about it, is that those class members will get the benefit of this settlement, but to the extent that there's a release or anything, they wouldn't be giving that up. But I'll let them address that.
Your Honor, well, if you have more questions.
Well, and the other idea would be sort of the flip side of it. You could certify future student athletes as class members, but you would not deem them to have released certain claims, so that they wouldn't have had things applied to them that they weren't on notice of before they happened. And well, just before we turn to Mr. Killaroo, somebody says that White was disapproved by the Supreme Court in AmChem. I couldn't find it. It disapproved the part about saying if it's fair, you can certify it. But I didn't see anything else.
No, so that's not correct. There is a discussion in outcome about a different issue in White, and it was some commentary about it. I don't remember what it was now, about not the issue, not any of the issues we're arguing now. There was something else, that another issue in White, and I just have to check what it is, and we can submit on this, where White said something about something that outcome has now indicated is not correct, but it has nothing to do with any of the issues we're talking about now, where there was just some side issue concerning the Rule 23 process. And I can go back and find it, even if maybe one of my colleagues can look at it and we'll figure out what
That's
that
all
is.
right. So what about not certifying future athletes now, but every year in the future, starting a new class of 2025 athletes, 2026 athletes? They get notice, they have an opportunity to object. They can't exactly opt out, but if they didn't want to, those would be the NCAA's rules by that time. If they didn't want to obey them, they'd have to not.
So that would be similar to the process we're describing with the objectors. In other words, it sounds to me like your Honor is describing that instead of as the process that that they're already bound and they're objecting, that you'd actually view it as a procedure to extend the class for another year. Again, that's not what we agreed to in the agreement, but it sounds like our process would also accomplish that due process idea. But what you're suggesting, I think it goes to the same point, right? Which is the idea to give future entrants an ability to raise whatever objections they have and, and to talk about it. So I guess that's another type of, it's not one we've ever discussed between us, but it would be a similar, I think it would accomplish a similar objective, but I can't speak to it because we haven't agreed to
Okay.
that.
Just give me one more second. Well, what about this different interest in injury? Do you think, how would you answer whether your class reps who were participating when you were negotiating this deal had the same interest in injury as future student athletes?
So the case on this is Cohen versus Brown University. Says, and also your Honor's own discussion of the infamous substitution effect as a barrier or non-barrier to class certification.
That was a question.
Which is what Brown says, the Cohen case and your Honor has written, is the fact that in a competitive market, when you change the rules, it's going to have different outcomes, so that there are different winners and losers, is not the type of conflict between class members or class reps that raises this, because there's a unified interest. But what we're comparing it to is the current set of NCAA restraints versus the world of the settlement. That's the comparison. And there's a unified class interest in the injunction going forward in changing this current restraints in exchange for a system that will yield billions of dollars of new opportunities, new scholarship opportunities, permanent NIL, or arbitration. All these different benefits are unified. The fact that in that system there will be different winners and losers because it's a competitive market is not the type of conflict that is disabling, because what's causing the different injuries, if you will, is not this, it's not the rules, it's that the competition between the athletes is different, right? In other words, you'll be a better athlete or worse athlete. Someone's at this point in their career, someone at not. Someone picks this school, someone picks another school. And it's true that if someone gets a position, someone else might not get a position.
Right, but there's other things like the asbestos one. Some people have asbestosis, some people have been exposed but don't yet have asbestosis. They may not have the same injury or interest, but it's not because it's someone else's to blame.
That had a different issue, which is that when you're dealing with a single damages pot, the issue of different people wanting those damages in different ways can sometimes create a conflict. We avoided that here because we don't have common damages pots. In other words, we have an NIL, BNLI damages fund. We have a video game, fund. We have the individual opportunities fund, and then we have the additional services, the pay for play fund, each of which was separately negotiated in accordance with our expert analysis of the value of the claims, and we never make any trade-offs between one fund and another fund. So we don't have those issues in asbestos, and we don't have issues where our rules are picking winners and losers. I'll talk about roster limits a bit in this. The roster limits apply to all class members. This is not a case where we go, you're going to have a roster spot and you're not going to have a roster spot. And in fact, you couldn't have a separate class of people subject to roster limits because it's every member of Division I is subject to these roster limits. What you don't know until after the fact is who's going to make a roster or not, right?
I think this is more the defendant's issue. But I did have one or two other questions for you before I turn to them. When you say that future I don't know, maybe maybe people who were at one time current class members as well as future class members, if they can they can object to antitrust claims, but can they only object to new stuff, or can they object to the way it's always been and say it's not fair anymore?
Okay, so there are different pieces here, right? For damages, they can file about anything.
Right.
Both the new stuff, the old stuff, anything, okay?
No,
With respect to injunctive relief, there's no release of injunctive relief for anything that's not part of the settlement or its implementation, right? So if like someone has an objection to an NCAA transfer rule, we don't do anything about transfer rules in our settlement. There's nothing there. There's no bar for that, or any new rule the NCAA would come up is not there. The scope of the release is about injunction claims against what our settlement imposes. And for that, that's the release issue, right? That's the scope of the release. It's limited, it's narrow, but that's the scope. And we're just talking about what people
Trouble with the feed. Let's see if we can get this back up to speed here.
it's either PP or QQ, or maybe it's in a couple places.
okay.
That talks about the release, and it talks about money and benefits. The release claims are limited to money and benefits.
Well, I know what you mean, Your Honor. So
And so my question is, could that be narrower? Would it be better if that were narrower and said something like money and benefits related to NIL or athletic services?
So
So
that
it could
was
be money and
No.
benefits for how much do you get for your burger after your game or whatever.
I'm gonna go look at the language now. It was designed to try to be limiting. You know, it was designed to say what you're releasing is the NCAA rules that are continuing under the settlement relating to schools compensating the athletes. And it was designed to make sure it was not releasing claims about transfer rules or things that are not there. But I'd have to go look at the exact language, and I could do that right now
Some other
and
time.
see.
It could be more limiting.
I'm sure everything could always be more limited, right, in theory. But that was the negotiation was between us, was to limit it to just what was relevant to the settlement. If Your Honor thinks
Money
that it
and
could be
benefits.
more limited, we'd have to look and discuss it with the other side, obviously.
Okay, you go ahead.
Okay.
You may respond to whatever you care to respond to.
A number of things, just on this roster issue, Your Honor, or just on this futures issue, or everything. I'm happy to do both.
Everything.
Okay, let's start with the futures issue. One thing that I think has to be realized here, which is implicit in the citations Mr. Kessler gave you, is that the sports context is a unique context. There need to be clear rules of the under and compete under. And so that is why this 10-year issue is in the case in the first place. It does not or X for season one, Y for the next season, and have things constantly change from one year to the next.
Things like rosters.
Well, the roster limits are in the settlement, Your Honor, and they can be changed in the future, and there's protections for that. But the settlement is a 10-year settlement because it's true in every sport.